Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. Once again, we're going live. All righty. Hey, welcome everybody. This is a kind of a special, kind of unique live stream that I'm doing here in the Consumer Warrior YouTube channel, where I'm going to be going over an oral argument I did before the Court of Appeals. So again, my name is John Skiba. I'm a consumer and bankruptcy attorney in the state of Arizona. And a lot of what I do, probably half of what I do is bankruptcy, and the other half is I fight back against junk debt buyers. These are companies that go out and purchase accounts for pennies on the dollar and sue people and trying to get a judgment so they can garnish wages and all that kind of stuff. And so in this video, I'm going to share with you an oral argument I did in a case that I handled before the Arizona Court of Appeals, talk to you, kind of give you a behind the scenes as far as why the court does what it does, how the process is. And then also, hopefully you'll learn something from some of the arguments that we make and the way that the judges respond to them, because I think they can help you if you're dealing with a debt collection case as well as some of the techniques and approaches. So I want to jump in, and we're going to play some of this. This was a number of years ago. Gratefully, my appearance has changed somewhat. I was still keeping that football weight on just in case. But so kind of some backdrop of this. So Midland Funding, who's a junk debt buyer, they sued one of my clients and saying that they owed on this credit card debt. They said Midland was saying they bought this credit card. They sued my client. And we fought this thing tooth and nail through the Superior Court in Arizona. And it even went all the way to trial. And then we get to trial, and the witness that Midland brings in, typically, like, I don't believe they have a lot of knowledge about any of the documents or any of the information, but this was clearly a new employee. Often, if you do this long enough, I've done over 400 trials against debt buyers, and something you'll see is the same witnesses over and over again. So you kind of get to know kind of their approach to things. This is the only time I saw this witness, this poor witness. I think this was their only case, and maybe they got let go afterwards because she was not good. She didn't. Truthfully, I guess she was truthful. She admitted she didn't have a whole lot of knowledge about the account, about the documents, all that kind of stuff. And so we go through this trial and we win. And surprising to me, and frankly, a lot of the creditors' attorneys and the consumer attorneys in Arizona, Midland Funding files an appeal to the Court of Appeals. So in Arizona, the appeal goes from, just trial to this 3-judge panel at the Court of Appeals, who will rule on and determine if the judge at the trial court level, if they screwed up, if they made a mistake, kind of thing. So they file this appeal, and when they filed the appeal, I even had other creditors' attorneys reaching out to me going, what is Midland doing? And the reason why is, no matter which side of it on, when you appeal a case to the Court of Appeals, you always have to be careful, because it may impact things for years to come, other than just your case. Because if the court issues an opinion, an actual written opinion, it's binding precedent on cases that come later on. And so appellate attorneys always want to pick cases that have good facts. There's this saying in the law that bad facts make bad law, good facts make good law. And so they're like, this isn't one of the cases they wanted out there, where there was a bad witness, bad facts, she didn't know a whole lot. And as far as how that could negatively impact the credit collection industry going forward. So they're really surprised that they brought it. I was happy to argue it. So we went forward. They filed a brief, a written brief. I filed one. And then the court set oral argument, which I was again surprised that they did. So this is the 3-judge panel. I'm not going to play at least not in this one. I won't play the arguments of Midland Funding, but then it was my turn. And so in the Court of Appeals, what's kind of cool about it, you go in, there's 3 judges there. There's a lot of formalities that they follow there. And there's very strict time limits. And so I'm going to kind of point those out and give you some kind of behind the scenes play-by-play as we're going through this. But let's go ahead and start this and listen to what some of the questions the judges have and some of my opening here.
Is it Mr. Skiba? All right. Your argument?
Good morning, Your Honors. May it please the court. John Skiba appearing on behalf of Lizette Venslake. All right. First thing, like I said, there's formalities. May it please the court. You literally have to say that. As weird as it is, it feels like something out of old England or something like that. But that's something that legitimately you have to say is, may it please the court, and then go into your argument. Your Honors, the issue here with the underlying court, with Judge Warner, this is really a matter of reliability. How reliable are these statements that Midland Funding submitted, the Chase Bank statements? Now, Chase would have the court reduce the rule down to really two prongs. Basically, if they have possession of the documents and they have someone, not even someone from Midland Funding, as was in this case, someone state that the documents were relied on, that they are per se reliable. And if we take that out to its natural progression, I mean, the fact that they're stating that they're relying on these documents to which their witness testified they had no background knowledge as to how Chase Bank kept and maintained its records. They had no information how the documents were even transferred from Chase Bank over to Midland Funding. That doesn't speak to the reliability of the Chase Bank documents. I mean, frankly, it speaks to the negligence of Midland Funding in relying upon them, to rely upon documents to which you have no underlying knowledge.
Counsel, I understand your argument, but I've read some of these federal.
Real quick, so something to know about decorum in the court, whether it's a trial level, but particularly at the Court of Appeals level, is the way we prepare for this is the attorneys, we prepare as if, we're given a certain amount of time. I think it's 20 to 30 minutes. And there's literally in front of you on the desk, there's this clock. And as soon as you start, the clock starts ticking. You're not allowed to go a second over that. And so as attorneys, when we prepare for oral argument in front of an appellate court like this, I was a solo practitioner, so there's a lot of standing around in my office and actually reciting what I wanted to say over and over again. When I worked at a larger firm early on in my career, I would see when there were Court of Appeals arguments, we would have mock trials where the attorney would get up and start presenting their arguments, and then you have to be prepared that the judges can jump in, and they do. I mean, we're only a couple minutes into this, and they immediately jump in and with questions. And so it throws you off your game a bit, and you've got to be prepared to answer their questions. And so you got to know all the cases that they're going to reference. You're almost guessing of what they're going to go into, and be prepared to answer those questions.
Cases, and there's some pretty broad language in those federal cases. I know that that's not binding precedent on us. What would you say about that?
And the binding precedent thing, so what this judge is asking us is saying, look, there's some federal cases out there that are going to cause you some problems, that the language in there is not good for your side, and they're wanting me to explain that. But the court did note something, that it's not binding precedent because they're federal cases. This is a state court. Not only that, they're federal cases outside of the Ninth Circuit, outside of the state of Arizona. We're in the Ninth Circuit Court of Appeals. And so the court's acknowledging, the judges there, look, we don't have to follow that precedent, those cases that came before yours. But they're giving me a little bit of clue here that, look, we think this is kind of persuasive. You better rebut this. And let's see how I did. I would say that almost without exception, in the federal cases, there is this third prong, this indicia of reliability. There has to be something else. There has to be some testimony or something that gives the court some comfort that what they're receiving is reliable and accurate. And we saw that in State versus Parker. Judge Downey pointed out that the basis that the court made its ruling and found it reliable, they found that the Capital One employee who was testifying about Capital One documents was able to, testify that Capital One regularly made these documents. She was able to describe the transmission process from the vendors, and she was able to testify that these were normal business records of Capital One. That's something that we didn't have here. We had an employee from Midland Credit Management, Inc., a non-party, trying to testify on behalf of the plaintiff, Midland Funding, LLC, for documents that were created by Chase Bank. So there was this comfort that the Supreme Court could get in the Parker case, in that they had the person there who was creating the records. And I'm not arguing that it has to be the specific person in every instance who created the document, but clearly they were influenced by the fact that they had someone there who was at least familiar with the underlying processes, which we didn't have here.
So what's a
And so what we're doing here, and I probably didn't do a very good job. The background of this is that we're saying, and that this is at the core of all junk debt buyer cases, of saying, look, these documents are not reliable because in this case, we had a Midland Funding, the junk debt buyer, who was trying to introduce documents from the original creditor, but they're using a witness that doesn't have any understanding or information. And the idea behind a trial proceeding, or, no matter what kind of court proceeding it is that the information and the evidence and the documents, that they're going to be reliable, and that they're going to be the best evidence that we can find. And so they have to have a witness to authenticate and basically say, this document is what it says it is. But what they did is they had company A, Midland Funding, coming in testifying about company B's documents, even though they didn't have any idea what they were talking about. And so what we're discussing here is a case called State versus Parker in Arizona, which was just horrible. I can tell you before State versus Parker, we won every case, we being the consumer attorneys, because they didn't allow the debt buyers to do this. State versus Parker is a criminal case of all things, and it really threw a wrench into it. I'm trying to distinguish that and say, look, Judge, State versus Parker, this isn't what it says. And that's what we shouldn't even have to, but even, and I even go down there and say, even if we look at State versus Parker, there's things that are much different than the situation we have right here.
Average trial judge to do, they get hundreds of these motions for default judgments. They don't have the benefit of the case going to trial and having a live witness, and they've got affidavits attached from Midland. Midland does a lot of collection work throughout the state. What does the trial court need to have in an affidavit where it can admit and accept those credit card records? Usually it's just a statement or two that's got, the past due account. Usually there isn't even the original contract that's attached. It's just a statement or a few statements. And these are records from Chase or some credit card company, a lot of them. They've been turned over to a third-party collection agency like Midland. What does a trial judge need to see in that affidavit so that she can believe that the documents are authenticated and admissible under the business record exception?
Respectfully to this judge, I struggle with this argument. And the judge isn't advocating this, but this question of what's the judge supposed to do, it essentially says, look, do we have to, the courts are almost bending to the will a bit of this industry because it's so big, because they flood their courts with all these collection cases. To me, the better question is what should the debt buyers do? It seems like the debt buyers, they're the ones coming in utilizing the court system. They should be the ones who have to adjust their business practices to the rules of evidence and to the mechanisms that are in place to make sure that the courts get the best information, and the judgments are only entered if they get something that is legitimate and it's something that where the evidence is sound. I struggle with this question.
Your Honor, we need to see an affidavit, that a minimum meets the requirements of Rule 8036, that goes through those specific requirements and has the documents attached stating that at least reviewed those. The problem that we're getting is we often get...
From the current institution that's the party, or from the prior institution where they were originally created?
From the original.
Again, it's their world. We're just working it. If the judge interrupts, you stop what you're doing and take the question.
No creditor. Because that's where I think the reliability issue comes into play. We have a case like this one where you have a witness who frankly knew nothing of the original creditor's business practices, and frankly even conceded she hadn't even reviewed these documents prior to trial and giving her testimony.
Did she testify that Midland keeps these records in the ordinary course of its business and relies on them?
Well, and Judge Warner addressed that. In his ruling, he stated, she had in his words, she had parroted the magic words of Rule 8036, but his
you got to know the case cold, by the way. I'm patting myself on the back here. you have to know the case cold. You have to know the transcripts. You have to know the cases. You have to know it. And that's what you kind of lead. There's a ton of preparation. You have 20 minutes, but there's days of preparation that go into being able to answer these questions.
Finding was that there was nothing to support that. She had conceded time and again on questioning from myself, from the court, and even from her own counsel as to her knowledge of how Chase Bank keeps and maintains its records. and she didn't have any information or any answers. So the mere fact that she had stated that, the court said, wasn't persuasive. There had to be some kind of substance behind it.
If you'll allow me another question here, what about this, these statements in paragraph 33 of Parker, where our state Supreme Court said trustworthiness and reliability stem from the fact that Capital One regularly relies on the information that third parties submit as part of their ordinary course of business. And then it cites the Adafinte case and describes it as listing cases that permit business records of one entity to be admitted as a business record of another entity if the latter entity relies on the records and keeps them in the ordinary course of business. That certainly does not seem to require something in this case from Chase.
I think that, Your Honor's quoting from paragraph 33 of that decision. I don't think we can read paragraph 33 and not review paragraph 31 as well.
Boom. I'm ready. I'm ready for this one.
Where the court specifically said, the last sentence of paragraph 31, these facts qualify the entries in Ward's report as business records. So the court's saying, and if we look at the beginning of paragraph 33, it seems the issue raised was, do we have to have the actual person who's created these documents, who was involved in the preparation of them? And the court's saying, no, we don't. The courts regularly will admit documents, but there has to be some underlying basis and understanding of the underlying processes as far as how they're put together. And that makes sense because, as Judge Downey pointed out, if the court was to adopt what Midland Funding is proposing today, it effectively guts Rule 8036, and it really has no meaning. If the only thing that's required is possession of a document and saying that you're relying upon it, and then it comes into the court, one could see, as the court has pointed out, that the problems that could pose in many different areas.
I agree that it would gut the written rule of evidence for the business records exception, but isn't that what our Supreme Court has done in Parker?
Yes, that's what the Supreme Court did do in Parker. So, and what we're talking about here, so Rule 8036, Rule 803, these are the rules of evidence. And Rule 8036, Rule 803 is the rule against hearsay, saying that you can't use hearsay evidence in a trial. You can't go into court and testify that, hey, this is what so-and-so told me. And the written version of that is true as well. Essentially what you have is you have a document created by Citibank or whatever, and Midland Funding is bringing it in, and they're saying, hey, this is what Citibank told us. It's in this document right here. And so what I'm arguing here is saying, look, if we're going to follow what they're saying, if we're going to follow what the court is saying, as far as just allowing these documents to come in, it guts 8036, because 8036 has very specific requirements. They have to be able to, the person has to be able to testify about when the document was created, how it's stored, if they're doing it in the normal course of their own business. And if they don't have a witness that can do that, then it doesn't meet the requirements of 8036. For the courts to interpret it and apply this case law and say, well, that none of that matters, that's where we get into trouble. And that's why I said, look, it basically makes Rule 8036 the actual rule of evidence. It just eliminates it. And the judge here is saying, well, look, I agree, but isn't that what the Supreme Court did with State versus Parker?
Well, and let me weigh in here, because I don't read that language in Parker the same way. I'm interested in your take on it, because trustworthiness and reliability stem from the fact that Capital One regularly relies on the information that third parties submit as part of their ordinary course of business. That means that Chase submitted as part of Chase's ordinary course of business. And as I read Judge Warner's ruling, that's the missing link here. There is nothing to show that Chase submitted any of this as part of its ordinary course of business. That's how I read Parker. I don't know that there's any other reading of that sentence.
Correct. There is nothing that Chase has provided, and when the witness for Midland Credit Management was asked that very question, she had no guidance either. She had no information as far as how the documentation was transferred from Chase Bank to Midland Funding.
And that's what gives it indicia of reliability, such that, hypothetically speaking, if there had been an affidavit from a Chase custodian of records saying these are Ms. Van Slyke's credit card records, we created them in the ordinary course of business, we've sold this account to Midland, doesn't even have to say all of that, but something to show that Chase has created and submitted these records as part of its ordinary course of business. That's what I read Parker as requiring.
And I would be in agreement with that, because otherwise simple possession satisfies the rule.
Right.
which is problematic. And it's interesting because the way that this rule is applied in this case, we've actually reduced the bar as compared to what Chase would have to testify to. If Chase were sitting in that courtroom testifying about its own documents, it would be held.
I love that argument. I love that argument that I did. Because, and it's a good point to bring up, because so Chase was the original creditor here, and by the court providing, or the courts saying in their case law, saying, look, these debt buyers, Midland Funding, can come in and they don't, they really don't have to have a whole lot of information. If Chase Bank were sitting in the witness seat, they would not get away with that. They would have to actually, we've lowered the amount of evidence that's necessary for a third-party debt buyer to get these documents admitted. My opinion is that a lot of the court cases go this way just because of efficiency. The average large-scale junk debt buyer files almost 500,000 lawsuits a year. I mean, these are just filling the courts everywhere, second only usually to criminal cases that these debt buyers are submitting it. And so they've got to find a way to process these things. But what this does is they've effectively lowered the bar, because the original creditor would have to provide more information than the actual junk debt buyer is being required to provide.
To the standards of Rule 8036. But for some reason, we're saying that the bar should be lowered dramatically as to a company, a third-party debt buyer. Particularly, we have a witness who's 2 companies removed from Midland Credit Management, Inc., testifying on behalf of Midland Funding, LLC. And so
something real quick here. If you're dealing with the Midland Funding case specifically, often Midland Funding is who they're alleging it will be the plaintiff, but the witness will be from a sister company called Midland Credit Management. And so that adds a whole nother layer to everything. Midland Funding, Midland Credit Management, original creditor, and it adds to the problems. So
again, Your Honors,
Would it be sufficient if the custodian from Midland included in her affidavit that she was familiar with how Chase keeps its records, how it compiles its records, and is aware that those records conform with, government standards, whatever applicable standards are, and also that she, on behalf of Midland, regularly receives those records and they incorporate those records from Chase in their business records? Would that be a sufficient link?
I think that that's going in the right direction, because I think that's what happened in Parker. Ms. Ward was able to testify about those underlying steps as far as how the vendors' documentation came to Capital One, and then how she compiled those documents and created her own record.
So you would concede perhaps you wouldn't need a separate affidavit from Chase as long as the person in Midland, for example, the third party, had a familiarity with how those records were kept and could establish a foundation for how she was aware those records were kept at Chase or whatever the company was you're receiving the records from?
If the witness is able to provide some kind of foundation as to how the documents were created, that they at least address the elements of 8036. If they're merely being able to testify as to essentially what filing cabinet this is stored at Midland Funding, I don't see how that gets over the issue of reliability.
Why wouldn't it be just as easy for a company like Chase, when it sends these records out, and counsel, I'm sort of throwing this in your direction as well, to, when they send the records out to Midland, include an affidavit from a custodian of records saying these are our business records that we're.
That's a great question. And the question is, why don't they do this? Why? I've always said, if I went as an attorney, like general counsel for a debt buyer, I could fix a lot of these problems, because it's not a big problem. At least in theory, it's not a big problem, because it seems like a simple affidavit from the original creditor. Here's the John Skiba opinion, because obviously I don't work for these companies. I don't know. My opinion is, because one, they deal with such gigantic volume that what seems like a little thing is actually a big thing. And so getting an affidavit for each individual case, when you have 500,000 of them, becomes very burdensome on the original creditor and the other creditor. And the original creditor, you got to remember, they're selling these things for pennies on the dollar. So they don't really, they're not too concerned about, what your evidentiary issues are. They're basically taking the position, look, we're taking a haircut on this. You do what you want with it. The other thing that I think that they run into problems with those trying to get an affidavit is the cost associated with it, as far as, because they're going to have to end up paying more if they get that. But the main issue is that most of these cases end in a default judgment. 95% end in a default judgment, meaning that these things are getting zero scrutiny. No, essentially the court's saying, if you're not going to respond to it, then tough luck. You're going to have to just deal with it. So that's, I think, those two reasons, the cost, and then the fact that it's almost all default judgments that they're dealing with. But my response here is probably not great, and I don't think the court even appreciated it that much. They kind of chided me a little bit for it.
Submitting to you, wouldn't that be a pretty easy thing to do?
One would assume that would be easy, and one would think it would be equally as easy. These witnesses are routinely granted telephonic appearances in the court. Why can't a chase witness call in on the telephone as well, to give some comfort as to the reliability of the document? Because what this does, as these are admitted, it effectively eliminates any effective cross-examination by the defendants. Because we have a witness who has been allowed to lay foundation for documents they have no understanding of, and yet it puts us in a position where when we ask that witness questions, they don't know, but the document has already been admitted. It also deprives the court of any rational basis on which they can base the trustworthiness of the document or the reliability of the document if we don't have additional information other than, yes, we have the document and we've relied upon it. So based upon that, Your Honors, in conclusion, essentially and the court's brought up great questions as far as why don't certain things happen. And I think it's because Midland Funding would like the rules of the court essentially to adopt to its business practices.
I don't think that's true, counsel. I think they're confused. I think they're getting a lot of different direction from federal courts, different judges. They really just need to know, what do we need to do? And I think, in fairness to them, it is a little confusing to them.
Yeah, it's a little confusing. And it's true. But I can tell you, like, Arizona's an outlier. Arizona allows a ton of documents in on these kind of cases that you don't see in other areas. So most states bar these documents. So if you're not in Arizona and you're dealing with this, you're going to have a much better opportunity to keep these things out, to keep these documents out. But, the courts are kind of all over. And the courts, even with the State versus Parker case here in Arizona, that there's a lot of uncertainty when we get into from court to court, even in the superior courts, justice courts, as far as what they're actually, what they're allowing. Some will allow it in, some won't. Some judges will always say, well, I'll admit it and give it the weight it deserves. Which to me, if the document comes in, that it's likely that's not a good situation for the consumer. The only thing the thing that I have seen that might be the remedy to that is to ask for jury trials. When it comes to these kind of cases, the debt buyers don't want to do jury trials. And I think if you took it out of the hands of the judge and let the person who's deciding be a jury, I think that sometimes the consumer will get a better result.
So I guess I disagree with your position a little bit there. I understand what you're saying, but
my main point is we need some kind of indicia of reliability for these documents. And this case is a glaring example of how little the lower courts get. We get witnesses who really don't know much about anything related to the underlying process.
I think that applies to every case I ever sat on as a trial judge.
Okay.
So.
All right. But I don't have anything further, and I thank you, Your Honors.
That was my courtesy laugh.
So, no, that's a joke for the record. That's not true. All right. Thank you, counsel. We'll take this matter under advisement, and we'll issue a written decision in due course. Court's in recess.
All right. So what I thought was funny is how the judge says, I better make sure that it's clear, because they have the court reporter, they're typing that up. And something I learned when I played football at BYU is when I was a new player there, they have someone from the PR department come in and give the new players advice. And they're like, hey, if you're ever doing an interview, don't use sarcasm. Sarcasm does not come across in writing. I think the judge was making sure that in the record that everybody knew that was a joke there. So what they do is they then take it under advisement, meaning that they're going to think about it, and they issue a written ruling months later. It's not like you go home and you get this next week or something. It took like 2 or 3 months. We received an official ruling and we won that case. And something that's interesting that with appellate decisions, again, is that they are looking to see if the underlying court abused its discretion as the standard. If they didn't follow through like they were supposed to, if they didn't follow the rules like they were supposed to. And so it's not something where they retry the case. And you are in if you win at the lower court level, like we won at trial. It's almost like in football when they do instant replay. If they call a touchdown and then they go to review it, there has to be, undisputable evidence to be able to reverse the call that's on the field. Same kind of thing in an appellate type case, in that we won at the trial court level. So now the burden is on Midland Funding to come in and show that the plaintiff or that the court was so far out of bounds. There has to be, undisputable evidence that they were not, that the evidence should not have been or should have been admitted. That's what so they have a tough standard to go against. So that's again why the creditors bar was so kind of concerned about why would they appeal this when they lost at the trial level. So we did win that case. They issued what's called a memorandum decision. Most appellate courts, this is what they issue, memorandum decisions. They do not create binding precedent, which I was just like, this is one where we got a good win. We have good facts for us. The reasoning behind the opinion was awesome, but it doesn't create binding precedent. And that means that the other courts, lower courts, do not have to follow it, even though it would help out cases down the road. It's actually cited in these books right over here. These are the National Consumer Law Center books, and they have a whole section on defending debt buyer suits. They actually cite to it in there, saying this is one of the decisions that really helps consumers. I even went back after the fact and said, and asked for them to make it a published opinion so that it would create binding precedent, and they turned me down. So, but a win's a win. The client was happy. I told him, I said, hey, this client, I said, look, when we win this case, this is going to be something, your name is going to be associated with it forever. And it is. I even, when it was printed in this book, I photocopied a page and sent it to the client and said, look, you're in the textbooks. I knew that this was a case that we could get that, not only get you win, but help other people down the road. So we can still cite it, and I still use it in cases, but it's not binding. It's not something the court has to follow. It's just persuasive. The courts can look at it and say, maybe this will give us some idea of how the Court of Appeals might rule in a situation like this, but it's not binding on the parties. So hopefully that's helpful for you. Again, I'm John Skiba, founder of the Consumer Warrior YouTube channel. I'm an attorney in the state of Arizona. I do bankruptcy, debt defense. I'm going to be doing some more of these live streams, kind of going over. So I'm going to, on Thursday nights, every Thursday at 5:15 p.m. Arizona time. I don't know what time that is in California, Utah, whatever. It's Arizona time. We don't switch. I do a live stream, and I'll go over some of your questions. I see there's some questions in the chat section there on YouTube. I'll come back on Thursday and we'll do the questions. But I'm going to be, if you see a video out there of a court proceeding or debt collector or something like that you want me to respond to, let me know about it. I'm happy to do a response like this and kind of go over and give you my thoughts on it. But hey, thanks for checking in tonight. We will catch you next time.